Let's talk about judicial conflict of interest. Hi, my name is Carl Birkhead. I'm an attorney with Wirth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for almost 8 years now, and I want to help you make law easy by talking a little bit about what it takes to get a judge conflicted off of a case. So this is coming off of a question that came in, and I'm just going to read the question out because my memory's not that great sometimes. Can a judge who was a former prosecutor preside over a defendant's case after prosecuting that case? So I actually almost had this come up a couple years ago. I had a case in it wasn't in Tulsa County. I can't remember where it was, where my client was accused of a relatively serious felony, and I was working with the district attorney on that case who was prosecuting it. And we were so close to getting it resolved and so close to getting it done until that DA got appointed to be the judge in that county over that case. Obviously, that's a problem. That's called a conflict of interest. Uh, Quite literally, the judge is going to have all kinds of personal knowledge of the case. He's going to be very aware of the state's, evidence, their strategy, all of that. He can't then go and try the case as the judge. That's just too much. That's too much overlap. There's too much that he already knows from it. It's a lot. So luckily in that instance, the judge recused himself. I didn't have to do anything in that. But that's not always the case, and it's not always that extreme either. I mean, I've had cases where uh, the judges might know one party or the other party, and they'll just go ahead and make that disclosure in an abundance of caution, just to let the attorneys know that, hey, there might have been a prior personal relationship between the judge and one or both of the parties, in case anybody wants to ask the judge to recuse. So if in this instance, if the judge hadn't recused, I would have to do what's called, I believe, a Rule 15 motion. Basically, we'd have to go in the judge's chambers. I would make an oral motion for the judge to recuse. If the judge denied it, for whatever reason, decided they didn't feel like they needed to, now then I would have to file a written motion and get it, set to be heard. So always be aware of the fact that the judge doesn't just get to sit over your case forever. There are certain situations when the judge can be removed. Now, I will tell you, those situations are relatively far and few in between, because a lot of times, I mean, judges, they do take great care to make sure that there are no conflicts. But nobody's perfect. Everybody makes mistakes, and quite frankly, sometimes what one person thinks is a conflict, maybe the other person doesn't think the same way. That's why we have a court system of checks and balances. So if this is a situation where you think that there might be a conflict, definitely give me a call. We'll go over the facts. We'll talk about whether or not we think that we can get the judge to recognize the conflict and remove themselves. My name is Carl Birkhead. I'm an attorney with Wirth Law Office, and I want to help you make law easy.